Sabotage, judgment, dismissal. That's what attorney Andrea Lewis expected as she walked confidently through the frosted glass doors of Westfield Partners Law Group. What she never anticipated was how a single black woman in judicial robes would transform a career-ending moment into the most extraordinary display of authority the legal world had ever witnessed. Before we jump back in, tell us where you're tuning in from, and if this story touches you, make sure you're subscribed, because tomorrow, I've saved something extra special for you. The granite and glass fortress of Westfield Partners dominated the downtown skyline, its 50 floors of polished windows reflecting the morning sunlight like a monument to corporate power. For 20 years, the firm had represented the elite of American business, Fortune 500 companies, hedge fund billionaires, and politicians whose names appeared in history books rather than police blotters. Inside the immaculate 48th floor reception area, Executive Secretary Victoria Bennett maintained her kingdom with military precision. At 53, her silver blonde bob was cut with the same sharp edges as her personality. Designer glasses perched on her nose like weapons, allowing her to inspect and dismiss visitors with practiced efficiency. Security, we have an unauthorized person attempting to access the executive floor. Please remove this woman immediately. Victoria's voice echoed through the marble-floored reception area, her finger hovering over the panic button installed beneath her custom-built mahogany desk. Andrea Lewis remained perfectly still, her charcoal Armani suit impeccable, leather portfolio clutched against her chest. At 38, she'd spent 15 years building her reputation as one of the sharpest legal minds in corporate law. Today was supposed to be her triumphant arrival at Westfield, the culmination of months of secret negotiations and careful career planning. "Ma'am," Victoria continued, her voice dripping with theatrical disdain, "the service entrance is on the loading dock. Deliveries are accepted between 8 and 4 only." She gestured toward the elevator bank with a manicured finger. "Unless you have proper credentials, I'll need you to leave immediately." Several associates gathered near the conference room, smartphones already recording what promised to be another viral Karen moment. Andrea noticed their cameras but showed no reaction. Her dark eyes remained fixed on Victoria, studying her with unsettling calm. "Have you considered verifying my appointment before attempting to remove me from the premises?" Andrea asked, her voice measured and controlled. Victoria's laugh was sharp and performative. "Honey, I schedule every appointment for every partner in this firm. I can assure you someone like you doesn't have a meeting here today or any day." The phrase "someone like you" hung in the air like a thunderclap. The associates exchanged glances, their recording devices capturing every syllable of Victoria's thinly veiled prejudice. Jason Park, a junior associate who'd been with the firm for 2 years, whispered to his colleague while live streaming, "This is unbelievable. She's straight up refusing to even check if this woman has an appointment." His stream quickly gained viewers, 23, 47, 112. The numbers climbed steadily as viewers recognized the familiar scenario playing out in one of the city's most prestigious law firms. Victoria's confidence never wavered. "Security will be here momentarily. I suggest you save yourself the embarrassment and leave voluntarily." She turned to the gathering crowd of associates, playing to her audience. "Ladies and gentlemen, witness what happens when certain people think designer clothes grant them access to professional establishments." Preparing and narrating this story took us a lot of time, so if you are enjoying it, subscribe to our channel, it means a lot to us. Now back to the story. Andrea's portfolio shifted slightly, revealing the edge of an embossed judicial identification card. She tucked it deeper into the leather folder before Victoria could focus on the details. Her phone buzzed softly, the screen illuminated. "Chief Justice waiting. Full court session delayed until your arrival." Victoria caught a glimpse of the message and smirked. Probably her parole officer wondering why she's violating the terms of her release. The associates continued recording, the viewer count on Park's stream approaching 500. He narrated quietly. "She keeps asking the secretary to verify her appointment, but the secretary refuses to even check the system. Thomas Westfield III, managing partner and grandson of the firm's founder, emerged from the corner office, his tailored suit and gold cufflinks broadcasting his status more effectively than any introduction. At 62, his silver hair and patrician features had appeared in legal journals and business magazines for decades. "Victoria, what's the situation here?" His voice carried the easy authority of someone who'd never been questioned or challenged. Victoria straightened in his presence. "Mr. Westfield, this woman claims to have an appointment but refuses to provide credentials. I've called security to escort her out." Westfield assessed Andrea with a practiced eye. Expensive suit, professional demeanor, confident posture. But his assumptions aligned with Victoria's. "Ma'am, I'm Thomas Westfield. This is a private legal practice with strict security protocols. If you don't have a verifiable appointment, I'll need to ask you to leave." Park's livestream reached 700 viewers. His whispered commentary became more urgent. Now the managing partner is here, and he's not even asking for her name or checking her appointment either. Security Chief Richard Doyle arrived with 2 uniformed officers, hands resting visibly on their tasers. "Sir," Doyle reported to Westfield, "subject claims to have an appointment but has provided no verification. Shall we escort her out?" Westfield nodded. "Use the service elevator. Document everything for our incident report." Andrea checked her watch. A Patek Philippe that cost more than most junior associates. Monthly salaries. "I have exactly 15 minutes until my scheduled appointment. I suggest you verify my identity before taking actions your firm might regret." "Regret?" Westfield laughed, playing to the associates still recording. "The only regret here is that we've wasted 10 minutes on this disruption." "Security, please proceed." Doyle moved closer. "Ma'am, you need to come with us now. Don't make this more difficult than it needs to be." Andrea remained composed, her eyes never leaving Westfield's face. "I understand your confusion, but I strongly recommend you verify my appointment before proceeding further." Victoria's voice rose with theatrical impatience. "There is no appointment to verify. I've managed this office for 17 years. Every meeting with every partner goes through me." Andrea's phone buzzed again. The screen displayed, "Supreme Court Chief Justice, full court waiting, proceedings delayed, ETA?" Victoria saw the message and scoffed. Now she's getting texts about the Supreme Court. The delusion is concerning. Park's livestream hit 200 viewers. Comments flooded his screen. "This is blatant discrimination. They haven't even asked her name. Someone call the Bar Association." Wait, did that text say Supreme Court? The associates' recording spread to Twitter and Instagram. A legal blogger for the city newspaper began a live thread documenting the unfolding situation. Potential discrimination incident at Westfield and Partners. Multiple witnesses recording. Andrea opened her portfolio just enough to check something inside. Beyond the judicial ID, several documents were visible. One bore the seal of the state Supreme Court. Another showed legal letterhead with judicial appointment in bold type. She closed the portfolio before anyone could focus on the details. 10 minutes remaining, she said quietly. 10 minutes until what? Doyle demanded, hand now resting on his taser. Until you risk interfering with judicial proceedings, quote, Andrea replied, her voice calm but carrying an undertone of authority that made several associates exchange nervous glances. Westfield's patience evaporated. Enough theatrics. Either provide credentials now or leave with security. Andrea's eyes never left his face. In your 17 years managing this firm, Mr. Westfield, how many discrimination lawsuits has your company settled privately? The question hung in the air like a live grenade. Westfield's face flushed. That's completely irrelevant and inappropriate. Security. Remove her immediately. Doyle and his officers moved to flank Andrea completely. The crowd of associates pressed closer, phones recording from every angle. Park's viewer count hit 2,000, with comments flooding in too fast to read. Local news alerts began pinging on phones across the city. Developing. Discrimination incident at prestigious law firm Westfield and Partners. Victoria's confidence peaked. She'd created the perfect opportunity to demonstrate her value to Westfield. This is how we maintain standards in a professional environment, everyone. Some people think being loudly indignant grants them special treatment. She turned back to Andrea with theatrical sympathy. Sweetheart, whatever social justice campaign you're running, whatever discrimination claim you're trying to manufacture, it won't work here. We have too many witnesses who can testify to your disruptive behavior. Andrea's phone rang. The caller ID displayed, Governor's office, urgent. She didn't answer. 5 minutes remaining, she said quietly. Westfield noticed the caller ID and laughed. Now she's pretending the governor is calling. This is beyond ridiculous. Robert Chen, the firm's most senior Asian American partner, emerged from the conference room, drawn by the commotion. Unlike Westfield, he approached the situation with cautious assessment rather than immediate judgment. "What's happening here?" Chen asked, his voice measured and precise. Victoria jumped to answer before anyone else could speak. "This woman refuses to leave after being told repeatedly she has no appointment here." Chen studied Andrea carefully, noting her professional demeanor and calm composure. Something about her confidence seemed incongruous with Victoria's characterization of events. "Has anyone actually checked the appointment system?" Chen asked quietly. The question landed like a bomb in the marble lobby. Victoria's face flushed. "I don't need to check. I schedule all appointments personally." "That doesn't answer my question," Chen replied. "Have you verified there's no appointment?" The associates watching began to murmur. Park's live stream comments exploded. "Finally someone with sense. They never even checked? This is getting interesting." Victoria's finger flew across her keyboard, determination to prove herself right overriding her earlier refusal. She pulled up the calendar and scanned it quickly. "See? Nothing here for—" Her voice cut off abruptly as her eyes fixed on an entry. 3 p.m., Thomas Westfield 3. Meeting with Judge Andrea Lewis. Supreme Court Chambers Review. Priority Level 1. Her face drained of color. "There must be some mistake. I didn't schedule this." Chen leaned over to look at the screen. "It appears to be in the system nonetheless." Andrea opened her portfolio fully for the first time. She removed her judicial identification card and a formal letter bearing the state seal. "I am Judge Andrea Lewis of the State Supreme Court. I was appointed by the governor last month and confirmed by the legislature 2 weeks ago." The documents passed from hand to hand. Westfield's face went from flushed to ashen as he recognized the official credentials and his own signature on documents acknowledging the judicial appointment. This meeting was scheduled through proper channels to discuss Westfield and Partners' handling of the Chamber's review process, a mandatory evaluation of all firms practicing before the Supreme Court. Andrea continued, her voice now carrying the unmistakable authority of the bench. "Your firm's evaluation was scheduled for today at 3:15 p.m. Victoria stared at her computer screen in horror. The appointment was indeed there, marked with the highest priority level. Somehow she had missed it, or chosen to ignore it. That's impossible," Victoria stammered. "I would have known if a Supreme Court judge was coming. The appointment was confirmed by Mr. Westfield himself via email 3 weeks ago." Andrea replied, producing a printed copy of the email thread, Westfield's signature clearly visible at the bottom. The livestream viewer count hit 4,000. Comments exploded across social media. News vans began arriving outside the building. Doyle, the security chief, took 3 steps backward, hands now conspicuously away from his weapons. "Your Honor, I sincerely apologize for the misunderstanding." Andrea's focus remained on Westfield. "Mr. Westfield, as you are aware, the Chamber's review evaluates firms for their ethical standards, procedural compliance, and workplace culture, including their demonstrated commitment to diversity and equal treatment." The full implications hit Westfield like a physical blow. Not only had his firm publicly discriminated against a Supreme Court judge, but that same judge was now responsible for evaluating whether his firm could continue practicing before the highest court in the state. Chen stepped forward, professional instinct taking over. "Your Honor, on behalf of Westfield and Partners, I extend our deepest apologies for this inexcusable reception. There is no justification for how you were treated." Andrea nodded slightly. "The apology is acknowledged, Mr. Chen, but does not erase what transpired, especially given that it was witnessed by over 4,000 people and counting." She gestured toward Park's phone, still live-streaming the encounter. Westfield found his voice, desperation evident in every syllable. "Judge Lewis, this has been a terrible misunderstanding. Victoria was simply following security protocols. Was someone like you part of your official security protocol, Mr. Westfield?" Andrea interrupted, her voice now carrying the unmistakable authority of the bench. "Was refusing to verify my appointment before calling security part of your firm's official procedure?" Quote, the question hung in the air like an indictment. No one spoke. The associates, who had been recording, lowered their phones. suddenly aware they had documented their own firm's disgrace. Andrea checked her watch one final time. The Chamber's review requires a comprehensive evaluation of firm management, ethical standards, and cultural practices. Based on this reception, I am invoking Judicial Code Section 87(3), which authorizes an immediate suspension of a firm's Supreme Court practice privileges pending full investigation. Westfield staggered backward as if physically struck. Suspension? But we have 17 cases pending before the court. Billions in client interests. Then you should have considered that before allowing this discriminatory treatment in your lobby, Andrea replied calmly. Effective immediately, Westfield Partners is suspended from practice before the Supreme Court pending complete review. She removed an official document from her portfolio and handed it to Chen rather than Westfield. This order freezes all Westfield Partners litigation before the Supreme Court for a minimum of 30 days while a complete cultural and ethical audit is conducted. The document bore the official seal of the state Supreme Court and the signatures of 3 additional justices. This wasn't an impulsive reaction. This was a prepared response triggered by the firm's behavior. Victoria's hands trembled as she realized the magnitude of what had happened. Her prejudice and arrogance had just cost the firm billions in legal fees and potentially damaged its reputation beyond repair. "Your Honor," Chen said carefully, "may I ask what prompted this prepared suspension order?" This seems to indicate the court anticipated problems today. Andrea's gaze swept across the assembled attorneys, associates, and staff. The Supreme Court received 3 anonymous complaints about discriminatory practices at Westfield Partners over the past year. Rather than immediately investigating, we chose to conduct a real-world test of the firm's practices. I volunteered to appear unannounced. She gestured toward Park's livestream, still broadcasting to thousands. I did not expect to document such blatant discrimination, nor did I anticipate that it would be live-streamed to the public by your own associates. Westfield's legal mind finally engaged, searching desperately for procedural escape. This is entrapment. You created this situation deliberately. No, Mr. Westfield, Andrea replied coolly. I merely presented myself at your firm for a scheduled appointment. Every discriminatory action, every prejudicial statement, every failure to follow basic professional courtesy came from your staff, and ultimately from you. The suspension stands. She turned to address the associates still recording. As officers of the court, you all witnessed a violation of the ethical standards that govern our profession. I expect detailed statements from each of you within 48 hours. Park lowered his phone, the live stream still running. Yes, Your Honor. Andrea gathered her documents and turned toward the elevator. The Chamber's review team will arrive at 9 a.m. tomorrow to begin the audit. I suggest you prepare your staff accordingly. As she reached the elevator, she turned back one final time. Mr. Westfield, in my chambers I keep a framed quote from Thurgood Marshall. In recognizing the humanity of our fellow beings, we pay ourselves the highest tribute. Your firm failed that fundamental test today. The elevator doors opened. Andrea Lewis, State Supreme Court Justice, and the woman they had tried to throw out like an unwanted intruder, stepped inside her own elevator, in her own courthouse. The doors closed behind her, leaving chaos, careers in ruins, and over 5,000 witnesses to what would become a landmark moment in legal ethics. Inside the marble-walled Supreme Court chambers, 7 justices in black robes sat in silent judgment as Andrea Lewis recounted the events at Westfield Partners. Chief Justice Richardson, a 70-year-old jurist with 40 years on the bench, listened with growing concern as the evidence was presented, including the live stream video that had now been viewed by over 50,000 people nationwide. This behavior reflects a profound failure of professional ethics, Andrea concluded. The kind of casual discrimination demonstrated today raises serious questions about how this firm treats clients, witnesses, and opposing counsel who don't fit their preconceived notions of who belongs in legal spaces. Inside the Supreme Court chambers, Chief Justice Richardson's voice echoed against the marble walls. Based on this evidence, I concur with Justice Lewis's emergency suspension order. Westfield Partners' practice privileges before this court are officially suspended for 30 days, effective immediately. The 7 justices voted unanimously. Their decision would impact billions in pending litigation and send shockwaves through the legal community. Justice Carlos Menendez, a 20-year veteran of the bench, turned to Andrea. The live-stream footage is particularly damning. Ms. Bennett, someone like you, comment alone constitutes clear discriminatory intent. Justice Patel nodded in agreement. What troubles me most is that at no point did anyone simply ask for your identification or verify your appointment. Basic professional courtesy was completely absent. Andrea gathered her notes as the session concluded. The audit team is prepared to begin their investigation tomorrow morning. I recommend we assign Justice Williams to oversee the process given her background in professional ethics. The Chief Justice nodded gravely. Agreed. This isn't merely about one firm's behavior. This is about setting standards for the entire legal profession. When attorneys discriminate within their own offices, how can we trust them to uphold equal justice in our courtrooms? Back at Westfield Partners, chaos had descended upon the 48th floor. Thomas Westfield III barricaded himself in his corner office, making frantic calls to clients, judges, and political connections. Victoria Bennett sat at her desk, face ashen, as Human Resources prepared termination paperwork. Robert Chen called an emergency partners meeting in the main conference room. 27 senior partners gathered around the massive oak table, faces grim as they watched the live stream footage that had now been viewed by over 75,000 people nationwide. This is catastrophic. Jennifer Hargrove, head of litigation, announced bluntly, "We have 17 cases pending before the Supreme Court representing over $4 billion in client interests, all now frozen for at least 30 days. Michael Dawson, equity partner and head of client relations, scrolled through his phone with growing horror. It's worse than that. 8 major clients have already called, demanding explanations. 3 are threatening to pull their business entirely." Chen stood at the head of the table, his normally calm demeanor strained by the magnitude of the crisis. "Before we discuss damage control, we need to understand exactly what happened. How did we fail so completely in this situation?" All eyes turned to Victoria Bennett, who had been summoned to the meeting. She sat rigidly in her chair, hands clasped so tightly her knuckles had turned white. "I don't understand how this happened," she said, voice brittle with defensive anger. "The appointment was in the system, but I never received any notification. Someone must have added it without informing me." Chen pulled up the email records on the conference room screen. "The appointment was confirmed by Mr. Westfield himself 3 weeks ago. You were copied on the original correspondence." The email thread displayed for all to see Thomas Westfield's response confirming Judge Lewis's appointment, with Victoria clearly copied. The original email had included Judge Lewis's credentials, position, and the purpose of the visit. Victoria stared at the evidence, her carefully constructed narrative crumbling. I receive hundreds of emails daily. This must have been overlooked." "Overlooked?" Hargrove's voice cut like a knife. "Or deliberately ignored because you saw a black woman who didn't fit your image of a Supreme Court justice?" Victoria's face flushed. "That's completely unfair. I was following security protocols for unidentified visitors." "She repeatedly asked you to verify her appointment," Chen said quietly. "You refused. She asked to speak with management. You called security instead. At no point did you perform the basic professional courtesy of checking your system." Dawson slammed his hand on the table. "The suspension alone will cost us millions in billable hours. The reputational damage is incalculable." "And for what? Because our executive secretary couldn't be bothered to verify an appointment?" Before we jump back in, tell us where you're tuning in from, and if this story touches you, make sure you're subscribed, because tomorrow I've saved something extra special for you. Victoria's eyes filled with tears of frustration. "I've given 17 years to this firm. I've maintained the highest standards of professionalism. One mistake." "This wasn't a mistake," Hargrove interrupted. "The mistake would have been overlooking the appointment. What happened afterward was a choice, a series of deliberate choices that revealed a profound bias." Chen pulled up the live stream footage, now being dissected by legal commentators across social media platforms. "Victoria, please watch this and tell us if you still believe your actions reflect the highest standards of professionalism." The video played on the conference room screen. Victoria's voice echoed through high-quality speakers. "Someone like you doesn't have an appointment here. The help uses the service entrance. Probably her parole officer checking in." Each statement landed like a physical blow. Several partners winced visibly as the discriminatory comments played before them. When the video ended, silence hung heavy in the conference room. Victoria stared at the frozen screen, seeing herself through others' eyes for the first time. I didn't mean it that way," she whispered. "Intention is irrelevant," Chen replied. "Impact is what matters, and the impact of your actions has placed this entire firm in jeopardy." Westfield finally emerged from his office, looking decades older than he had that morning. He took his place at the head of the table, his authority now damaged beyond repair. "I've spoken with several justices," he announced. "The suspension is ironclad. The only path forward is complete cooperation with the audit and a demonstrable commitment to systemic change. Starting with accountability," Chen added, looking pointedly at Victoria. Westfield nodded grimly. "Miss Bennett's employment is terminated, effective immediately. Security will escort her from the building within the hour." Victoria's face crumpled. "Thomas, after everything I've done for this firm, for you personally, everything you've done," Westfield's voice cracked with strain. "What you've done is expose this firm to unprecedented liability, damaged our reputation beyond calculation, and jeopardized billions in client interests. Your discriminatory behavior reflects a culture that I, as managing partner, allowed to develop. We both bear responsibility for that failure. Preparing and narrating this story took us a lot of time, so if you are enjoying it, subscribe to our channel. It means a lot to us. Now back to the story." Chen stepped in, always the voice of strategic thinking. "We need to implement immediate reforms before the audit team arrives tomorrow. I propose a comprehensive action plan." He displayed a detailed slide on the conference room screen: immediate termination of all employees involved in the incident, mandatory bias training for all staff, from partners to support personnel, complete revision of security protocols to require verification before escalation, establishment of a diversity and inclusion committee with external oversight, creation of a client communication strategy, addressing the incident transparently, development of a formal apology to Justice Lewis and the Supreme Court Hargrove. This is a start, but we need to address the root causes. How did we create an environment where discrimination was normalized to this extent? Jason Park, the junior associate whose live stream had documented the entire incident, was invited into the meeting. He entered nervously, aware that his recording had both exposed and potentially saved the firm by documenting their willingness to acknowledge the problem. "Mr. Park," Chen began, "your live stream has been viewed by over 100,000 people. While this has created a significant crisis for the firm, your willingness to document wrongdoing rather than participate in it speaks to your character." Park shifted uncomfortably. "I didn't set out to damage the firm. I just couldn't stand by watching what was happening to that woman, to Justice Lewis, without creating a record." Westfield studied the young associate with new respect. "Your ethical instinct was correct, even if the consequences are painful for all of us. That's the kind of moral compass this firm needs to cultivate moving forward." He turned to address the entire partnership. "Tomorrow morning, Supreme Court auditors will arrive to begin their investigation. They will interview staff at all levels, review our policies and practices, and evaluate our culture for evidence of systemic discrimination." Dawson scrolled through his phone with growing alarm. "Our competitors are already circling. Davison Mitchell has reached out to 3 of our major clients, offering to take over their Supreme Court cases once the 30-day cooling period ends. Then we have 30 days to demonstrate that Westfield & Partners is capable of fundamental change," Chen replied. "This isn't just about surviving an audit. It's about becoming the firm we've always claimed to be." Victoria gathered her personal belongings under the watchful eye of security, her 17-year career reduced to a cardboard box and a walk of shame past the same associates who had witnessed her disgrace. As she reached the elevator, she turned back one final time. "I never thought of myself as prejudiced," she said quietly. "I always believed I was maintaining standards." Chen met her gaze steadily. "That's precisely the problem. You equated professionalism with a very specific appearance, background, and demeanor. Anyone who didn't fit that image was automatically suspect. The elevator doors opened. Victoria Bennett, executive secretary and gatekeeper, stepped inside for her final descent from the heights of corporate power. The doors closed on her tears and her 17 years of service to a culture that had finally been exposed. At 9 a.m. the following morning, Justice Elaine Williams arrived with a team of 5 auditors. Tall, silver-haired, and formidable, she had built her reputation on ethical reform within the legal profession. The Supreme Court had strategically selected her to lead the audit, a clear signal that this investigation would be thorough and uncompromising. "Good morning," she announced to the assembled partners. "Over the next 30 days, my team will conduct a comprehensive review of Westfield & Partners, practices, policies, and culture. We will interview staff at all levels, review internal communications, and evaluate your handling of cases involving minority clients and opposing counsel." Westfield stepped forward, the strain of the past 24 hours evident in his face. "Justice Williams, we are prepared to cooperate fully and implement whatever reforms the court deems necessary." Williams nodded without smiling. "That's an encouraging start, Mr. Westfield. However, intentions must be matched by actions. My team will be looking for evidence of systemic issues beyond yesterday's incident." The auditors dispersed throughout the firm, setting up temporary offices in conference rooms and interviewing spaces. Partners and associates were scheduled for detailed interviews. Staff members from all departments were asked to complete confidential surveys about their experiences and observations. By noon, troubling patterns had already emerged. 3 minority associates reported being consistently assigned to less prestigious cases than their white counterparts. Support staff described an unwritten dress code that penalized cultural expressions through hair, clothing, or accessories. Clients from certain neighborhoods or backgrounds were routinely directed to junior partners, regardless of case complexity or billing potential. Justice Williams summoned Westfield and Chen to a preliminary briefing. "Gentlemen, we've identified concerning patterns that suggest yesterday's incident wasn't an anomaly, but a symptom of deeper cultural issues." She displayed a data analysis showing clear disparities in case assignments, promotion rates, and retention across demographic lines. "These numbers tell a compelling story of systemic bias operating within your firm for years, possibly decades." Westfield stared at the evidence, his defensive posture gradually giving way to genuine dismay. "I've always prided myself on running a meritocracy. I never imagined." "Few people imagine themselves as participants in discriminatory systems," Williams replied. "Yet the data demonstrates clear patterns that cannot be explained by merit alone." Chen studied the numbers with the analytical precision that had made him a successful attorney. "These disparities are statistically significant. The question now is how we address them comprehensively rather than cosmetically." Justice Williams nodded approvingly. "That's precisely the approach that might salvage your firm's reputation and practice privileges. Superficial changes won't suffice." That afternoon, an unexpected visitor arrived at Westfield & Partners. Justice Andrea Lewis stepped off the elevator, causing an immediate hush to fall over the reception area. Without Victoria Bennett's gatekeeping, she was immediately recognized and respectfully greeted. "Justice Lewis," Westfield said, hurrying to meet her. "We weren't expecting you today." "This isn't an official visit," Andrea replied calmly. "I came to speak with you privately about yesterday's events and the path forward." In Westfield's office, Andrea declined his offer of refreshments and came directly to the point. "Mr. Westfield, what happened yesterday wasn't about me personally. It was about a culture that automatically questions the legitimacy of certain people in professional spaces." Westfield nodded solemnly. "Justice Lewis, I can only offer my deepest apologies for how you were treated in our offices." "I don't want apologies," Andrea replied. "I want change. Real, substantial change that ensures no one else experiences what I experienced yesterday." She opened her portfolio and removed a document. "This is a conditional reinstatement proposal. If approved by the full court, it would allow Westfield & Partners to resume limited practice before the Supreme Court in 15 days rather than 30, provided you implement specific reforms immediately." Westfield reached for the document with visible relief. "That would be tremendously helpful. Our clients—" "Before you get too excited," Andrea interrupted, "review the conditions carefully. They are non-negotiable and will require significant restructuring of your firm's culture and practices. The conditions were indeed substantial: creation of a diversity, equity, and inclusion officer position with partner-level authority and compensation, revision of hiring practices to eliminate implicit bias in recruitment and interviewing, implementation of blind work assignment protocols to ensure equitable distribution of prestigious cases, establishment of a diverse committee to review all terminations and promotions for potential bias, mandatory quarterly bias training. Their corrective: your firm has operated under flawed assumptions about what professionalism looks like, who belongs in legal spaces, and how authority is recognized. Westfield studied the document carefully. Some of these changes will meet resistance from the old guard partners. Then perhaps it's time for the old guard to reconsider their positions, Andrea replied simply. The legal profession is evolving, Mr. Westfield. Firms that adapt will thrive. Those that resist will become increasingly irrelevant. She rose to leave but paused at the door. Yesterday, your executive secretary judged me based on appearance rather than credentials. That same judgment likely happens to clients, witnesses, and opposing counsel who don't fit a narrow image of what a real legal professional looks like. Westfield nodded slowly. I understand that now in ways I never did before. Andrea's gaze was penetrating. Understanding is merely the first step. Implementation is what matters. My experience yesterday was witnessed by hundreds of thousands of people. Your firm's response will be equally public. After Justice Lewis departed, Westfield called an emergency partnership meeting. All 37 partners gathered in the main conference room, tension palpable as he distributed copies of the conditional reinstatement proposal. This is our path forward, he announced. These changes aren't optional if we want to continue practicing before the Supreme Court, and more importantly, if we want to become the firm we've always claimed to be. Several of the older partners shifted uncomfortably. Harold Blackstone, 72 and one of the firm's founding partners, spoke first. Thomas, some of these demands are excessive. Blind work assignment? Partner-level DEI officer? These changes undermine our traditional structure. Chen replied before Westfield could speak. Our traditional structure is precisely what created this crisis, Harold. We've operated under the illusion that our practices were merit-based when the data clearly shows otherwise. He projected Justice Williams' statistical analysis onto the screen. Look at these numbers. Associates of color leaving at triple the rate of their white counterparts. Female attorneys assigned to support roles rather than lead counsel positions at a ratio of 5-to-1. These aren't anomalies. They're patterns that reflect our unconscious biases. Jennifer Hargrove stood, her presence commanding immediate attention. I've been with this firm for 22 years. In that time, I've been the only woman to make equity partner. Not because other women weren't qualified, but because our definition of qualified has been fundamentally skewed. She pointed to the reinstatement proposal. These changes aren't radical. They're the bare minimum required for a modern legal practice. If we resist them, we're not just risking our Supreme Court privileges. We're ensuring our eventual irrelevance in a changing profession. Quote, the debate continued for hours, with the partnership gradually dividing into reform advocates and traditionalists. By evening, Westfield called for a formal vote on accepting the conditional reinstatement proposal in its entirety. The result: 29 in favor, 8 opposed. The motion carried. Westfield stood at the head of the table, his authority now tied to reform rather than tradition. Beginning tomorrow, we implement every element of this proposal. Those who cannot support these changes should consider whether their future lies with Westfield and Partners. 3 of the opposing partners submitted their resignations the following morning. Their departure, rather than weakening the firm, created space for new perspectives and fresh approaches. Robert Chen was appointed interim managing partner to oversee the implementation of reforms. His first action was to promote Jason Park, the associate whose live stream had documented the discrimination incident, to head a newly created Ethics and Accountability Committee. The 15-day conditional reinstatement period transformed Westfield and Partners with breathtaking speed. Physical changes appeared first. The reception area's intimidating marble desk replaced with an open, welcoming design. Security protocols revised to emphasize verification before action. New artwork featuring diverse legal pioneers like Thurgood Marshall, Ruth Bader Ginsburg, and Constance Baker Motley adorned the hallways. But the deeper changes were cultural and structural. The newly appointed Diversity, Equity, and Inclusion Officer, Maria Rodriguez, recruited from the Civil Rights Division of the Justice Department, received full partner status and voting rights. Her first initiative, implementing blind work assignment protocols that removed names and demographics from case distribution. "We're not lowering standards," Rodriguez explained at her first all-staff meeting. "We're expanding our definition of excellence beyond the narrow confines that have limited our perspective for decades." The blind assignment system revealed startling patterns. Associates previously overlooked for prestigious cases demonstrated exceptional skills when judged solely on their work product. Clients previously directed to junior partners received more appropriate counsel matched to their actual legal needs rather than perceived status. Jason Park's Ethics and Accountability Committee established an anonymous reporting mechanism with protection from retaliation. Within days, previously hidden issues surfaced: microaggressions that had become normalized, client comments that had gone unchallenged, assignment patterns that reflected unconscious bias. "We can't address what we don't acknowledge," Park told the partnership during his first formal presentation. "These reports aren't accusations. They're opportunities to recognize patterns we've been blind to." Robert Chen, serving as interim managing partner, organized daily progress briefings for Justice Williams' audit team. The transparency itself marked a cultural shift, problems openly discussed rather than hidden or minimized. Before we jump back in, tell us where you're tuning in from, and if this story touches you, make sure you're subscribed, because tomorrow I've saved something extra special for you. "What impresses me most," Justice Williams noted on day 10 of the audit, "is not the speed of change but its authenticity. Your firm isn't merely checking boxes. You're fundamentally re-examining your professional identity." Thomas Westfield, stripped of his managing partner title but still an equity partner, found himself in an unfamiliar role, student rather than authority. He attended every training session, participated actively in discussion groups, and met privately with associates from underrepresented backgrounds to hear their experiences directly. "I built this firm in my own image," he confessed during a particularly powerful sensitivity training session. "I never stopped to consider that my image, my perspective, was inherently limited by my own experiences and privileges." The mandatory bias training, led by respected academics and practitioners, went far beyond superficial diversity talks. Sessions explored how seemingly neutral professional standards often encoded specific cultural norms, how patterns of interruption and acknowledgement in meetings reinforced existing hierarchies, how client development opportunities were unconsciously filtered through networks built on shared backgrounds and experiences. Not everyone embraced the changes. 5 more partners resigned during the 15-day period, unable or unwilling to adapt to the new paradigm. Their departure created opportunities for talented attorneys previously overlooked for advancement. Lisa Washington, a brilliant tax attorney who had been passed over for partnership 3 times despite bringing in substantial business, found herself suddenly elevated to equity partner status. Her first official act was establishing a mentorship program specifically for associates from underrepresented backgrounds. "This isn't about charity or quotas," she explained at the program's launch. "This is about ensuring that talent isn't overlooked because it doesn't package itself in familiar wrapping." On day 14 of the conditional reinstatement period, Justice Andrea Lewis returned to Westfield and Partners for an official progress assessment. The reception area, now staffed by a diverse team trained in professional courtesy, immediately recognized her and notified the appropriate partners. Chen greeted her personally, escorting her to the conference room where the full partnership awaited. The contrast with her previous visit couldn't have been more striking: respect and professional courtesy replacing suspicion and hostility. "Justice Lewis," Chen began, "thank you for returning to our firm. We've implemented all conditions of the reinstatement proposal and would like to share our progress with you. Preparing and narrating this story took us a lot of time, so if you are enjoying it, subscribe to our channel. It means a lot to us." Now back to the story. The presentation that followed demonstrated not just compliance, but genuine transformation. Statistical analysis showed measurable changes in case assignments, client distribution, and internal advancement considerations. Anonymous feedback from staff at all levels indicated a profound shift in day-to-day experiences. Justice Lewis listened attentively, occasionally asking incisive questions that probed beyond surface metrics to underlying cultural changes. Her focus wasn't on whether rules had been followed, but whether mindsets had evolved. "Mr. Chen," she said after the presentation concluded, "these changes are impressive for a 15-day period, but sustainable transformation requires ongoing commitment beyond the spotlight of crisis. What mechanisms have you established to ensure these reforms outlast the current scrutiny?" Chen nodded, appreciating the question's depth. "We've instituted quarterly diversity audits with results reported directly to clients and published internally. Our compensation structure now ties partner bonuses to measurable diversity and inclusion metrics. And our hiring committee has been completely restructured to eliminate historical biases in our recruitment process." He paused, then added with genuine conviction, "But perhaps most importantly, we've experienced the tangible benefits of these changes. Cases that might have been overlooked are receiving innovative approaches. Clients who might have been directed elsewhere are bringing substantial business. Talent that might have left is choosing to stay and contribute." Justice Lewis nodded thoughtfully. "Results matter. When firms discover that diversity and inclusion enhance rather than undermine excellence, the motivation for change becomes self-sustaining." She opened her portfolio and removed an official document bearing the Supreme Court seal. "Based on the audit team's assessment and my personal observations, I am authorized to lift the suspension of Westfield and Partners practice privileges before the Supreme Court, effective immediately." The partners exchanged relieved glances, but Justice Lewis wasn't finished. "This reinstatement comes with a condition. Westfield and Partners will serve as a case study for the legal profession. Your transformation, both the crisis that precipitated it and the reforms that followed, will be documented as a teaching tool for law schools and firms throughout the state." Chen didn't hesitate. "We accept that condition without reservation. Our mistakes and our progress should serve as lessons for others." Justice Lewis smiled for the first time. "That response confirms you've understood the deeper meaning of this process. True professional growth requires not just acknowledging mistakes but ensuring others learn from them." As the meeting concluded, Thomas Westfield approached Justice Lewis privately. The former managing partner had aged visibly during the 15-day period, humility replacing arrogance in his bearing. "Justice Lewis," he said quietly, "I want to personally apologize for how you were treated in our offices. The culture that allowed that treatment was ultimately my responsibility as managing partner." Andrea studied him carefully, noting the genuine regret in his expression. "Apologies matter, Mr. Westfield, but actions matter more. How will you personally ensure these changes outlast this crisis?" Westfield straightened, finding a measure of his former confidence, now tempered with wisdom. "I've created an endowment in my family's name to fund diversity scholarships at 3 law schools. I've also volunteered to speak about this experience at Bar Association events, not as an expert on diversity, but as someone who learned its value through painful failure." Justice Lewis nodded approvingly. "Personal growth often begins with public humility. Your willingness to share this experience may help other firms avoid similar mistakes." As she prepared to leave, Jason Park approached hesitantly. The young associate whose live stream had documented her mistreatment now headed the firm's ethics committee, a remarkable rise in just 15 days. "Justice Lewis," he said, "I wanted to thank you for turning what could have been simply a punitive measure into an opportunity for meaningful change. Your approach transformed not just our policies but our fundamental understanding of professionalism." Andrea smiled. "Mr. Park, never underestimate the power of documentation in creating accountability. Your decision to livestream that incident was an act of moral courage that made all of this possible." As Justice Lewis departed Westfield and Partners for the second time, she left behind a firm fundamentally transformed. The changes weren't merely cosmetic or temporary. They were structural and cultural, designed to outlast the immediate crisis and create sustainable evolution. The Supreme Court's audit team submitted their final report 1 week later. The document, over 300 pages of detailed analysis, became required reading for managing partners throughout the state. What had begun as a discrimination incident evolved into a blueprint for institutional reform across the legal profession. Justice Williams presented the findings at a special session of the State Bar Association. Over 500 attorneys filled the conference hall, with thousands more watching the live stream, the same technology that had documented the original incident now disseminating its lessons. "The Westfield case represents both failure and redemption," Justice Williams explained. The failure lies in allowing discriminatory practices to become so normalized that a Supreme Court justice could be treated as an intruder in a legal setting. The redemption lies in the comprehensive reforms that transformed not just policies but culture. She displayed key statistics from the audit: diverse attorneys now receiving equitable case assignments, client satisfaction metrics improving under new protocols, retention rates equalizing across demographic groups. The numbers told a compelling story of institutional transformation. Perhaps most significantly, Williams continued, Westfield and Partners' financial performance has actually improved during this period. Quality work that was previously overlooked is now being recognized and utilized. Clients who might have been directed elsewhere are receiving appropriate representation. The firm is stronger, not weaker, for embracing inclusive excellence. In the audience, Robert Chen and Jason Park exchanged satisfied glances. The crisis that might have destroyed their firm had instead elevated it, not just in reputation but in actual performance. After the presentation, legal industry leaders surrounded Justice Williams with questions about implementing similar reforms in their own organizations. The conversation had shifted from damage control to proactive transformation. Back at the Supreme Court, Chief Justice Richardson convened a special committee to examine the court's own practices and procedures. We cannot hold law firms accountable for biases we haven't addressed in our own institution, he acknowledged. This audit process must extend to the bench itself. Justice Andrea Lewis was appointed to head the internal review. Her experience at Westfield and Partners had demonstrated that even the most prestigious legal institutions could harbor unconscious biases that undermined equal justice. The courts must be the standard bearers for fairness and equal treatment, she told her fellow justices. Not just in our rulings, but in how we interact with attorneys, staff, and the public. The internal audit revealed subtle but significant patterns within the court's own operations. Which attorneys were interrupted during oral arguments, whose briefs received the most attention, how clerks were selected and mentored. Each pattern reflected unconscious preferences that could potentially influence judicial outcomes. We pride ourselves on impartiality, Chief Justice Richardson acknowledged when the findings were presented. Yet these patterns suggest we too have work to do in recognizing and addressing our own biases. The Supreme Court implemented its own reforms: blind clerk selection processes, standardized evaluation criteria for oral arguments, regular training for justices and staff on recognizing unconscious bias. The changes weren't mandated by external pressure, but embraced as essential to the court's core mission of equal justice. 6 months after the incident at Westfield and Partners, the legal landscape across the state had transformed dramatically. Law firms large and small implemented versions of the Lewis Protocols, named in honor of the justice whose experience had catalyzed change. Law schools added curriculum specifically addressing professional ethics in diverse environments. Bar associations established certification programs for inclusive practice management. Victoria Bennett, the former executive secretary whose discriminatory actions had triggered the crisis, found herself unable to secure comparable employment within the legal industry. Her name and face captured in the viral livestream had become synonymous with entrenched bias. The permanent consequences of her actions served as a cautionary tale throughout the profession. She eventually found work at a small insurance office, a humbling position for someone who had once controlled access to one of the city's most prestigious legal firms. The experience fundamentally altered her perspective on privilege, access, and judgment. "I never saw myself as prejudiced," she confessed during a mandatory diversity training session at her new workplace. "I thought I was maintaining standards. I never stopped to question why my definition of professional looked so specific, or who it excluded." Thomas Westfield followed through on his commitment to speak openly about the firm's transformation. His presentation at the National Bar Association, titled "When Privilege Blinds: Lessons from Institutional Failure," drew standing-room-only crowds. The former managing partner who had once embodied traditional legal culture now advocated passionately for its evolution. "The greatest threat to true excellence," he told audiences, "is the comfortable assumption that we already embody it. Progress begins when we acknowledge our limitations, not as failures but as opportunities for growth." Robert Chen eventually assumed the permanent managing partner position at Westfield and Partners, the first Asian American to lead a top-tier firm in the state. Under his leadership, the diversity initiatives implemented during the crisis period expanded and deepened. Clients who might have left during the scandal instead remained loyal, impressed by the authentic transformation they witnessed. "We don't view diversity as compliance or crisis management," Chen explained in a profile for the American Bar Association Journal. "We recognize it as essential to excellence in modern legal practice. Different perspectives yield better solutions for increasingly complex legal challenges." Jason Park's Ethics and Accountability Committee became a permanent fixture in the firm's governance structure. The young associate whose moral courage had documented discrimination received partnership consideration years ahead of the traditional timeline, not as reward, but in recognition of the leadership qualities he had demonstrated during crisis. "Documentation creates accountability" became Park's mantra, a principle he taught to every new associate joining the firm. The willingness to record and acknowledge problems is the first step towards solving them. Justice Andrea Lewis continued her own path of leadership, using her position on the Supreme Court to advocate for systemic changes throughout the legal system. The incident that might have been merely humiliating instead became the catalyst for her most enduring contributions to jurisprudence. "True justice requires more than correct legal reasoning," she often said. "It requires an environment where every person is treated with equal dignity and respect, not just in theory but in daily practice." Quote, 1 year after the incident, Westfield and Partners hosted a special reception honoring Justice Lewis and the transformation she had inspired. The event took place in the same reception area where she had once been treated as an intruder, now redesigned as an inclusive space welcoming to all. Leaders from across the legal community gathered to celebrate not just one firm's change but an industry-wide evolution. The Lewis protocols had spread beyond their state, with law firms nationwide adopting similar reforms. What began as crisis response had become best practice. "Today we celebrate not just what we've overcome but what we've become," Robert Chen told the assembled guests. "A year ago, our firm faced its darkest moment, a public exposure of biases we hadn't acknowledged even to ourselves. Today, we're stronger, more innovative, and more truly excellent because we embraced that moment as opportunity rather than disaster." Justice Lewis rose to address the gathering. The woman who had once been threatened with forcible removal from this very space now commanded its complete and respectful attention. "The transformation we celebrate today wasn't inevitable," she reminded them. "It required courage, from the young associate who documented discrimination rather than participating in it, from the partners who chose difficult change over comfortable denial, from staff at all levels who spoke truth about their experiences." She surveyed the diverse gathering of legal professionals, a community fundamentally different from what it had been a year earlier. "The law has always claimed to treat all persons equally," she concluded. "But equality on paper means nothing without equality in practice. True justice begins when we recognize the humanity in every person who seeks it, regardless of appearance, background, or circumstance. That recognition isn't merely moral, it's essential to the integrity of our entire legal system." The applause that followed wasn't merely celebratory but affirming, a community acknowledging a fundamental truth about their profession and committing to its continued evolution. Outside the reception, a plaque had been installed in the building's lobby. It bore a simple inscription that captured the lesson of their collective journey. "Justice begins with recognition. Progress begins with accountability. Excellence requires both." The words served as daily reminder to everyone entering Westfield and Partners that their transformation wasn't complete but ongoing, a continuous commitment to recognizing humanity in all its diverse expressions and ensuring that recognition shaped every aspect of legal practice. 2 years after the watershed moment at Westfield and Partners, the ripple effects of Justice Andrea Lewis's transformation of the legal landscape continued to expand in unexpected ways. What began as a discriminatory confrontation in a law firm lobby had evolved into a national movement for inclusive excellence across the entire justice system. The American Bar Association invited Justice Lewis to deliver the keynote address at their annual convention, where attorneys from all 50 states gathered to explore evolving standards in legal practice. The convention center's main hall was filled to capacity, with thousands more watching via livestream, the same technology that had documented her mistreatment now amplifying her vision for reform. "The legal profession stands at a crossroads," Justice Lewis began, her voice carrying the quiet authority that had become her trademark. "For centuries, we've claimed to uphold equal justice while maintaining systems that privilege certain voices, perspectives, and appearances over others. The gap between our stated ideals and our daily practices has undermined public trust in our most fundamental institutions." She paused, surveying the diverse audience before her. 2 years ago, I experienced firsthand how deeply these biases are embedded in our professional culture. But what might have remained an isolated incident instead became a catalyst for systemic change. Not because I hold judicial authority, but because thousands of legal professionals recognized a truth they could no longer ignore. Before we jump back in, tell us where you're tuning in from, and if this story touches you, make sure you're subscribed, because tomorrow, I've saved something extra special for you. The presentation that followed wasn't merely inspirational but practical, a detailed roadmap for institutional transformation that any legal organization could implement. The Lewis protocols had evolved from crisis response into comprehensive best practices, with measurable outcomes documented across hundreds of firms nationwide. The data is unequivocal, Justice Lewis explained, displaying compelling statistics on the main screen. Firms that have implemented these protocols report higher client satisfaction, improved staff retention, more innovative case strategies, and, perhaps most convincing to skeptics, increased profitability. The financial metrics captured attention even from traditionalists who had initially dismissed diversity initiatives as idealistic rather than practical. Law firms implementing the Lewis protocols showed average revenue increases of 23% over 2 years, with client retention rates improving by 37%. These numbers reflect a fundamental truth about excellence in modern legal practice, Justice Lewis continued. Homogeneous environments produce homogeneous thinking. Diverse perspectives yield better solutions for increasingly complex challenges. In the audience, Robert Chen and Jason Park represented Westfield and Partners, now known simply as Westfield Chen following the firm's comprehensive rebranding. Their transformation from crisis epicenter to industry leader had made them sought-after speakers at legal conferences worldwide. After Justice Lewis's keynote, Chen participated in a panel discussion about implementing institutional change. "The most powerful lesson we learned," he told the packed room, was that diversity isn't a checkbox or compliance issue. It's a competitive advantage in an increasingly complex legal environment. He shared specific examples. A complex international tax case where staff with multicultural backgrounds identified opportunities others had missed. A class action lawsuit where diverse legal teams better understood plaintiff experiences. A corporate negotiation where varied communication styles achieved breakthrough results. These successes weren't accidental, Chen emphasized. They resulted from systematically incorporating multiple perspectives into our approach to legal challenges. Excellence requires diversity, not as a moral aspiration, but as a practical necessity. Jason Park, now a full equity partner at 32, led a workshop on creating accountability systems within legal organizations. The young attorney whose live stream had documented discrimination had become an expert in using technology to create transparency and measure progress. Documentation creates accountability, he told workshop participants. Modern legal practice requires metrics that go beyond billable hours and win rates to measure true excellence, including how equitably opportunities are distributed, how effectively diverse perspectives are incorporated, and how consistently professional respect is maintained. Park's workshop introduced innovative technologies for tracking equity metrics within legal organizations, tools that quantified patterns previously dismissed as subjective impressions. The data revealed uncomfortable truths about how opportunities, recognition, and advancement were distributed in many firms. These aren't opinions or feelings, Park emphasized as participants examined the metrics. These are measurable patterns that affect professional development, client service, and ultimately justice itself. Preparing and narrating this story took us a lot of time, so if you are enjoying it, subscribe to our channel, it means a lot to us. Now back to the story. While the convention showcased progress, resistance to change remained entrenched in portions of the legal establishment. A panel of managing partners from traditional firms questioned whether the Lewis protocols represented unnecessary disruption to established practices. The legal profession has functioned effectively for centuries with consistent standards of professionalism, argued James Harrington, managing partner at a 150-year-old firm. These new protocols risk undermining traditions that have served our profession well. Justice Lewis, invited to respond, approached the microphone with measured calm. The question isn't whether our profession has functioned, it's who it has functioned for and who it has functioned against. Traditional standards of professionalism have too often served as proxies for specific cultural backgrounds and appearances. She gestured toward the convention hall, where attorneys of diverse backgrounds, ages, and presentations mingled professionally. Look around this room. The legal profession is evolving not because of abstract ideals, but because our clients, our communities, and our challenges are increasingly diverse. Excellence requires meeting people where they are, not where tradition dictates they should be. The audience erupted in spontaneous applause, the momentum clearly shifting toward evolution rather than entrenchment. Even Harrington nodded reluctantly, acknowledging the practical reality that his firm's largest clients were now requiring diversity metrics as conditions for retaining legal services. Beyond the convention center, the Lewis effect continued transforming legal practice nationwide. Law schools revised their curricula to incorporate bias awareness and inclusive professional ethics. Courts implemented new protocols for ensuring equitable treatment during proceedings. Bar associations established certification programs for inclusive practice management. Victoria Bennett, the former executive secretary, whose discriminatory actions had triggered the original crisis, found unexpected redemption through her own journey of growth. After 2 years of struggling to find stable employment, she enrolled in a paralegal certification program at a community college. Her instructor, recognizing her name from the infamous incident, initially considered asking her to withdraw from the program. Instead, he assigned a special project, a comprehensive analysis of how unconscious bias affects daily interactions in legal settings. Victoria approached the assignment with humility born from painful experience. Her research paper, titled "When Gatekeeping Becomes Barrier Building: A Personal Journey," explored how her own unexamined biases had shaped her professional identity and decision-making. "I equated professionalism with specific appearances, vocabularies, and backgrounds," she wrote. "I never questioned why my definition of belonging looked so particular, or who it systematically excluded." The paper's unflinching self-examination earned not just academic recognition but publication in a prestigious legal ethics journal. Victoria found herself invited to speak at law firms implementing the Lewis protocols, her experience serving as powerful testimony to why change was necessary. "I believed I was maintaining standards," she told audiences of legal professionals. "I never recognized that those standards were designed to maintain a specific status quo rather than serve actual justice." Her journey from perpetrator to advocate demonstrated a truth at the heart of the Lewis protocols. True transformation required not just structural changes, but personal growth, the willingness to recognize and address one's own unconscious biases. Thomas Westfield, the former managing partner who had overseen the discriminatory culture at his firm, continued his own evolution through establishing the Westfield Foundation for Inclusive Legal Education. The foundation provided scholarships to law students from underrepresented backgrounds and funded research on barriers to equity in legal practice. "My greatest failure became my most important education," Westfield often said during foundation events. "I discovered that being an effective legal professional requires more than technical expertise. It requires the humility to recognize our blind spots and the courage to address them." The Foundation's annual report documented concrete impacts: over 200 scholarship recipients now practicing law, research that identified specific barriers in legal education and practice, and implementation guides helping firms apply the Lewis protocols in different practice contexts. Justice Andrea Lewis herself continued advancing reform from her position on the Supreme Court. Her judicial opinions became renowned for their clarity, precision, and awareness of how legal principles affected diverse populations. Law students studied her reasoning not just for its doctrinal soundness, but for its practical wisdom about how justice functions in complex societies. Beyond her judicial role, Justice Lewis established the Center for Inclusive Excellence in Legal Practice, a think tank developing evidence-based approaches to eliminating bias throughout the justice system. The center's research extended beyond law firms to examine courts, law enforcement, corrections, and legal education. "True justice requires more than good intentions," Justice Lewis explained during the center's launch. "It requires systems designed to recognize and address the unconscious biases we all carry." Equal treatment under law begins with equal recognition of human dignity in every interaction. The center's most significant initiative was the Judicial Equity Project, a comprehensive program training judges to recognize and mitigate bias in courtroom proceedings. The project documented troubling disparities in how judges addressed attorneys, questioned witnesses, and managed courtroom dynamics based on race, gender, and other characteristics. The bench itself is not immune to unconscious bias, Chief Justice Richardson acknowledged during the project's implementation. Our commitment to impartiality means nothing if we don't actively examine how our own perceptions and assumptions affect judicial proceedings. The project's success in reducing documented disparities led to its adoption by judicial training programs nationwide. Courtrooms traditionally dominated by hierarchical authority began evolving toward environments where respect flowed in all directions, enhancing not just equity, but the quality of justice itself. 3 years after the watershed moment at Westfield Partners, Justice Lewis was invited to speak at the grand opening of the National Museum of Legal History's new permanent exhibition, Equal Justice: America's Unfinished Journey. The exhibition chronicled both historical milestones and ongoing challenges in creating a truly equitable legal system. Justice Lewis stood before a display featuring the viral video that had documented her mistreatment, now preserved as a teaching tool for future generations of legal professionals. The moment that might have remained private humiliation had instead become catalyst for national transformation. This video captures more than individual bias. She told the assembled legal historians, educators, and practitioners. It documents a moment when our profession could no longer maintain the comfortable fiction that our stated ideals matched our daily practices. She gestured towards subsequent exhibits showing the concrete reforms that had followed: statistical improvements in equitable treatment, structural changes in major institutions, and testimonials from legal professionals whose careers had been transformed by more inclusive practices. The journey toward equal justice remains unfinished, Justice Lewis acknowledged. Biases deeply embedded in our systems and ourselves require ongoing recognition and correction, but we've demonstrated something powerful through this process: that legal excellence and equal dignity are not competing values but essential companions. The museum exhibition included an interactive component where visitors could experience simulated legal interactions from different perspectives, helping them recognize subtle patterns of differential treatment that might otherwise remain invisible. Empathy isn't merely emotional, it's intellectual, Justice Lewis explained as she demonstrated the exhibit. Understanding how others experience our legal systems is essential to designing systems that truly deliver equal justice. As the formal program concluded, a young law student approached Justice Lewis with visible emotion. "Your Honor," she said hesitantly, "I'm in my first year at law school. Before the Lewis protocols, someone like me wouldn't have been taken seriously in legal settings." Justice Lewis studied the young woman carefully, noting her natural hairstyle, cultural jewelry, and the confidence with which she carried herself despite historical barriers. "Someone like you," Justice Lewis replied with a warm smile, "is precisely who our legal system needs. Someone who brings authentic perspective, lived experience, and professional excellence without compromising identity to fit outdated norms." She gestured toward the exhibition chronicling the transformation of legal practice. The changes you see here weren't created by judicial authority alone. They required thousands of individual choices: attorneys who spoke up instead of remaining silent, firms that chose growth over tradition, clients who demanded better representation. The young student nodded thoughtfully. "I used to think I'd need to change who I am to succeed in law. Now I understand that being authentically myself is actually valuable to my practice." That's the heart of inclusive excellence, Justice Lewis affirmed. Not pretending differences don't exist, but recognizing the unique value they bring to our shared pursuit of justice. As Justice Lewis prepared to leave, she paused before a quotation engraved on the museum wall, words from her keynote address that had become a mantra for the evolving legal profession. "Justice begins with recognition. True recognition requires seeing each person's full humanity. When we limit who belongs in professional spaces, we limit not just individual potential, but justice itself." The words captured the essence of transformation that had begun with a discriminatory confrontation and evolved into a movement reshaping one of society's most fundamental institutions. What started as crisis had become legacy, not of one judge's authority, but of a profession rediscovering its highest purpose. 3 years earlier, a secretary's prejudice had nearly blocked a qualified judge from entering a law firm. Today, that moment had opened doors for countless others, not through force of authority, but through the power of recognition, accountability, and the unwavering belief that true excellence requires full humanity. The legal profession's journey toward inclusive excellence continued, with new challenges emerging and old resistances recurring. But the path forward had been irrevocably altered by a simple truth: justice requires seeing each person's dignity before seeing their differences. In courtrooms, law offices, and legal classrooms across the nation, That recognition was transforming not just who delivered justice, but how justice itself was understood. Up next, you've got two more standout stories right on your screen. If this one hit the mark, you won't want to pass these up. Just click and check them out. And don't forget to subscribe and turn on the notification bell so you don't miss any upload from us.